Welcome to my channel, where we discuss everything about things politics, especially about the 2023 presidential election in Nigeria. Already you all are aware of the inauguration brouhaha all over the country, for which President Muhammad Buhari and the Secretary to the Federal Government, Boss Mustafa, has assured that nothing will stop the handover of power to the new administration on May 29, 2023. And the reason why the issue of inauguration of the president-elect Bola Tinubu became an issue was when the APC began to fly the interim government card. So people begin to wonder what is going on. So it kind of bring up issue of is he going to be sworn in or not? Is he going to be sworn in on May 29 or what? Even the DSS, Department of State Services, they waded in to say that there are plots by some people to disrupt or to stall the inauguration of Bola Tinubu as president-elect on May 29, 2023. They said it's going to go ahead no matter what anybody says. But there are others who are saying, wait a minute, is this going according to the law? Some people are saying, is it going according to the law? Those who are for Bola Tinubu, they say, look, all over since 1999, and Festus Keyamo, one of the spokespersons of the presidential campaign of the APC, says since 1999, every president that won election had been sworn in, and that it doesn't stop those who are aggrieved from going to court while the president-elect will carry on in the office, and the petition in the Tribunal will go on up to the Supreme Court, as the case may be. That's the argument of Festus Keyamo and many people who think like him, especially supporters of Bola Tinubu, the president-elect as declared by INEC and the candidate of the APC. But there are others who say that Bola Tinubu's case is different from all the former president-elects. When Obasanjo was declared president-elect in 1999, he met the requirement of Section 134, subsection 2 of the 1999 Constitution as amended. So his situation is different from the situations Bola Tinubu finds himself. Similarly, when Obasanjo was re-elected in 2003, he also met the requirements of Section 134, subsection 2 of the Constitution. When Yaradua was declared president-elect, he met the requirement of Section 134, subsection 2 of the Constitution. When Goodluck Bello Jonathan was declared president-elect in 2011, he met the requirement of Section 134, subsection 2. When Muhammad Buhari became president-elect in 2015, he met the requirement of Section 134, subsection 2. When he was re-elected in 2019, he met the requirement of Section 134, subsection 2. Now, by the time Asiwaju Bola Ahmed Tinubu was declared president-elect on March 1, 2023, he did not meet that requirement of Section 134, subsection 2, as others have met. Now, don't get me wrong. My understanding of it is based on what I have been told by what I have heard from the former Attorney General and Minister of Justice of Nigeria, Chief Michael Andoaka, who confirmed on an interview with Arise Television that Section 134, subsection 2, and subsection 2B in particular, that this matter has been addressed. Now let us refresh our memory what that section is saying. That section is saying that Section 134, subsection 2B of the 1999 Constitution states that a candidate for an election to the office of president shall be deemed to have been duly elected where there have been more than 2 candidates for the election. He has the highest number of votes cast. That's A. He has the highest number of votes cast at the election. So let me take it again. A candidate for an election to the office of president shall be deemed to have been duly elected where there have been more than 2 candidates for the election. A. He has the highest number of votes cast at the election. B. He has not less than 1/4 of the votes cast at the elections, each of at least 2/3 of all states in the federation and the Federal Capital Territory. Now, a ruling of the Supreme Court in 2008, according to Michael Andoaka, did declare that and the Federal Capital Territory is conjunctive. It means that after you get to 24, we get 25% in 24 states, you also need to get 25% in the Federal Capital Territory, Abuja. Because if you look at it, it's just a simple English that any layman should be able to understand. But some other people have disagreed on this. People like Femi Falana, SAN, he said that there is nothing special about Abuja, that if you can get 24 states or 25 states, that you are good to go. If you can get 25% in 24 states or 25 states, and you have the highest number of votes cast, that you are good to go, that there is nothing special about Abuja. But other learned men like Abakoba, Michael Andoaka, they have come to say this is a simple, clear English. That if you get 24 states out of the 36 states, you must get 25% in Abuja. Now, because Asiwaju Bola Ahmed Tinubu did not get 25% in Abuja, that is why this issue of inauguration Brouhaha began to emerge. But in any case, if the presidency, as they promise that they'll go ahead with the inauguration, nobody will stop them from doing it. They hold the the cohesive powers of governance, nobody can stop the inauguration of Aswad Bola Ahmed Tinubu. Nobody can stop it now, except something is done before the election, in terms of the court judgment comes before the election. Before the inauguration. Unless the court judgment comes before the inauguration. But for that, I think everything is set for him to be sworn in. But to avoid all these issues about whether it's the right thing that somebody who has not gotten 25% in Abuja is sworn in or not. A senior advocate of Nigeria, Olisa Abakoba, has provided a solution to the problem by letting us to know that indeed it is possible to thrash out the presidential election petition in 7 days. So if it can be done in 7 days, then there will be no problem. It means that the election petition about the challenges, about those election petitions of those challenging the declaration of Aswad Bola Ahmed Tinubu as president-elect or winner of the election will be settled in just 7 days. So, but let us look at why Olisa Abakoba believes that it is possible or that it is doable. Because recently, Olisa Abakoba said that it is possible to conclude presidential election petitions in April, provided that the courts are very proactive. The court system are very proactive, that they are ready to do the work. They are ready to do the work. They are proactive. They can handle it, he said. He noted that the tension around the call for an interim government was due to expectations that the tribunal may not deliver judgment before May 29. Abakoba said that under the arbitration matters, orders and direction are issued to resolve complex jurisdictional and procedural issues. In the statement he issued, he urged the Presidential Election Tribunal to adopt the procedure very familiar with speedy conclusions of arbitration matters. The senior advocate of Nigeria listed the issues raised by the Labour Party and its candidate Peter Obi, who insists he won the April 25 poll. Abakoba said that the interpretation of Section 134 of the 1999 Constitution as to whether 25% of the votes in the FCT is compulsory is a candidate permitted to stand the election when he is a senatorial candidate. Issues regarding qualification of APC candidates, he said. Now, there are 3 issues he pointed out there. You know, one of the issues that Peter Obi has tabled before the election petition tribunal, was interpretation of Section 134, which we have just read a short while ago. That, he said, can be easily thrashed out. That's what Abakoba is saying. The next one is whether the vice presidential candidate of APC, Kashim Shettima, is a candidate in the election, being the fact, as alleged by the Peter Obi petition, that he was a candidate for senatorial election and still a candidate for vice presidential election. Okay? Which, because of that Peter Obi is demanding their disqualification. One of the reasons is demanding for their disqualification. Then other issues has to do with regarding qualifications of APC candidates. Okay, we all know that there is an issue about alleged drug case of Tinubu in Chicago in the 90s, which is an issue that they want the court to look into. Based on that matter, whether Bola Tinubu is qualified to contest for the election ab initio. So Awakova is saying that if the petitions were arbitration proceedings, an arbitrator may issue a procedural order to address all complex disputes and deliver a partial final award. Now, what Awakova was saying is this matters, this points, the issue of Section 134, the issue of whether Kashim Shettima contested for 2 elections, being nominated for 2 positions, the issue of qualification, whether Aswaju and Shettima are qualified for the election and all that it can be easily trashed out. The only issue that could delay is the issue of that the election did not follow the rules and regulations, which means in that case it might require getting some of the election materials, which will prove a problem. But I think the fundamental ones, if within 7 days, the appeal court can handle it, and in a matter of few days, those who are aggrieved will go to the Supreme Court, and Supreme Court will trash it out, and all this matter could be settled before May 29. And at the end of the day, whatever will be remaining will be perhaps issues about electoral malpractices, ballot box snatching, violence, distortion of results and all that. Especially this issue about the result and the IRIF being different from the result at the polling units. So those ones can go ahead while the president continues to remain in office, having settled the other fundamental issues, Section 134, the qualification issues and all that. To me, I think that Abakoba's solution is a good way to go, to be able to address, to take care of almost everything. Those who are aggrieved, their case will be heard. Those who feel that as Bola Tinubu won free, fair, and square, they will get fair hearing. And at the end of the day, the person that will be sworn in based on the fact that there is no more serious legal encumbrance in performing his or his duties. Now, the senior advocate of Nigeria charged the Tribunal and the Supreme Court to give the order, address the jurisdictional issues raised, and release final summary judgment. He said that between the Tribunal and Supreme Court, the petitions can be resolved within 7 days from today. This will cool the temperature in Nigeria on the issue of interim government, he added. Of course, Abakoba had already said it, interim government is an illegality. The Constitution of Nigeria has no place for a interim government at all. But in any case, if this matter didn't go to, if the court didn't resolve the matter before May 29, nothing will stop Aswad Bola Tinubu from being sworn in. He will be sworn in while the matter continues in court. That is it's a settled matter already on that. But what Abakoba is suggesting is that if you have accelerated hearing, you can dispense with the issue of the legitimacy. Of course, right, and everybody's saying that Aswad doesn't have the legitimacy. But they are saying that there is a challenge to that legitimacy, that it ought to have been resolved before May 29. But if it is not resolved, it's not the fault of Aswad Bola Tinubu, it's the fault of the judicial system in settling the matter before that. Abakoba stated that the required speed would be a radical departure from the present policy, where case management plays a limited role in judicial outcomes. Speed of justice is the mantra that our judiciary must proclaim very loudly. This is needed in the presidential petition proceedings urgently. So he was saying that this is needed urgently. To him, he sees it as the solution to the issue of interim government. Those who talk about interim government. But even in the issue of interim government, it was the APC that brought the issue of interim government. I've done a video before where I showed you where the governor of Kaduna State, Nasiru El-Rufai, brought up the issue of interim government. He was the one that brought it up. That there are people in APC who lost out in the governorship and presidential primaries, who are bent on scuttling the election so that there will be interim government. Now, but since the election took place, it is not unlikely that this same set of people are also plotting to see that the inauguration doesn't take place. So those people are in the APC. So if government security agencies are looking for those who are trumpeting interim government, they should go look at the rank and file of the APC. Who are those disgruntled among them? They are really the main architects of the interim government brouhaha that we all are hearing about. Thank you for watching this video, and if you are new to my channel, you have not yet subscribed to my channel, subscribe to my channel, hit the subscription button, hit the notification bell. When you subscribe to my channel and hit the notification bell, anytime I have a new video, you will be among the first to know. God bless you.